Welcome to the Real Free News audio podcast. Today, an exploration of Judge Mariana R. Pfaelzer's historic ruling that struck down California's Proposition 187, her marriage to attorney Frank Rothman, and the broader debate over judicial power, ethnic influence, and the long-term impact of 1990s immigration decisions on America's 2025 border and sovereignty crisis. In the annals of American legal history, few cases illustrate the profound impact of individual judicial decisions as starkly as the invalidation of California's Proposition 187. Passed overwhelmingly by voters in November 1994 with nearly 59% support, the initiative aimed to curtail public benefits for undocumented immigrants and mandate reporting of suspected unlawful presence to federal authorities. Yet, within months, U.S. District Judge Mariana R. Pfaelzer issued a preliminary injunction, and by 1998 her permanent ruling had dismantled its core provisions, citing federal preemption and 14th Amendment violations. This outcome not only nullified a direct expression of popular will, but also set a precedent that has hamstrung state-level immigration enforcement for decades, culminating in a sovereignty crisis that persists into 2025. Mariana R. Pfaelzer, appointed by President Jimmy Carter in 1978, served as a linchpin in this saga. Born Mariana Richardson in 1926 in Alhambra, California, to a family who operated a modest flower shop, she navigated early career barriers as a woman in law, eventually partnering at the influential firm Wyman, Pfaelzer, Rothman, and Judicial before ascending to the federal bench. Her rulings in the consolidated cases against Proposition 187, League of United Latin American Citizens versus Wilson, emphasized the exclusive federal authority over immigration, drawing on precedents like Pfaelzer versus Doe, 1982, to strike down education denials and benefit restrictions. Pfaelzer's decisions, upheld on appeal until Governor Gray Davis abandoned the fight in 1999, effectively rendered the proposition a legal nullity, despite its voter mandate. The personal dimensions of Pfaelzer's life, particularly her 1985 marriage to prominent attorney Frank Rothman, add layers to this narrative. Rothman, a powerhouse in entertainment law and former chairman of MGMUA, brought his own formidable influence to the union. Their partnership, while private, intersected with broader cultural and legal currents, including Rothman's Jewish heritage and connections to civil rights advocacy. As Proposition 187 ignited national debates on immigration, the interplay of judicial power, personal alliances, and ethnic influences raises questions about the forces shaping American policy. This article delves into Pfaelzer and Rothman's roles, the absurdity of one judge's outsized authority, and the pattern of Jewish involvement in immigration liberalization, patterns that during the 1990s simmered beneath public discourse but exploded into critiques by the 2020s, often invoking the Clergy Plan as evidence for understanding these dynamics. The judicial hammer, Pfaelzer's role in dismantling Proposition 187. Mariana Pfaelzer's handling of Proposition 187 exemplified the raw power vested in a single federal judge. Appointed to the Central District of California, she inherited a wave of lawsuits filed mere days after the measure's passage, including challenges from the ACLU, MALDEF, and other civil rights groups. On December 14, 1994, Pfaelzer granted a preliminary injunction blocking most provisions, arguing they intruded on federal immigration supremacy. Her 1995 summary judgment extended this, invalidating the education ban under Pfaelzer versus Doe, which mandated public schooling for all children regardless of status. By November 1997, she ruled the initiative unconstitutional on its face, a 32-page opinion decrying it as a scheme to regulate immigration, a domain reserved to Congress. The impact was immediate and devastating for Proposition 187 supporters. What began as a voter revolt against perceived fiscal burdens, estimated at billions in services for 1.6 million undocumented residents, crumbled under Pfaelzer's gavel. Her March 1998 final judgment enjoined key sections, ordering statewide dissemination of the ruling to agencies, schools, and hospitals. Critics, including Governor Pete Wilson, lambasted the delay over 3 years as judicial sabotage, accusing her of stalling to undermine the law's momentum. Wilson's office appealed to the Ninth Circuit, but the process dragged until Davis's 1999 mediation effectively buried the proposition. Pfaelzer's tenure, spanning nearly 40 years until her 2015 death, included other high-profile cases, like a $600 million judgment against Countrywide Financial, but none so politically charged as this. Pfaelzer's independence was lauded by colleagues. Chief Judge George H. King called her the epitome of what a federal judge ought to be, yet her rulings fueled accusations of bias. Proposition 187 proponents decried the abuse of discretion in allowing one jurist to override millions of voters, a sentiment echoed in contemporary critiques of nationwide injunctions. In an era of justifiable anti-immigrant sentiment, her decisions preserved access to services for undocumented families, but at the cost of deepening California's partisan divide and accelerating the Republican Party's decline in the state. The proposition's ghost lingers in 2025 border debates, a testament to how one judge's interpretation can reshape demographics and politics for generations. Frank Rothman's influence, from boardrooms to the bench. Frank Rothman, Pfaelzer's husband from 1985 until his death in 2000, embodied the nexus of legal acumen and cultural power that amplified her judicial footprint. Born in 1936 on New York City's Lower East Side to Jewish immigrant parents, his father a pharmacist and gambler in the community, Rothman rose from humble roots to become a titan of entertainment law. A Fordham Law graduate, he co-founded Wyman, Pfaelzer, Rothman, and Cachell, where Pfaelzer joined as a partner in the 1970s, navigating gender barriers in a male-dominated field. By the 1980s, Rothman chaired MGM/UA, orchestrating blockbuster deals for films like Rocky and The Terminator, amassing wealth and connections in Hollywood's elite circles. Rothman's Jewish identity was overt and influential. Raised in a tight-knit Ashkenazi milieu, he endowed scholarships at USC Gould School of Law and supported Jewish family services early in his career. While no direct records tie him to the NAACP or SBLC, his era's Jewish legal figures profoundly shaped civil rights, including immigration. Rothman himself advised on high-stakes mergers, but his marriage to Pfaelzer, publicized in 1985 Los Angeles Times profiles, placed him adjacent to her Prop 187 docket. During the 1994 to 1999 litigation, media noted their union casually, framing Pfaelzer as the wife of MGM UA chairman, but without probing deeper influences. Rothman's legacy extended beyond entertainment. He mentored young lawyers and championed philanthropy, including Jewish causes. Obituaries in 2000 highlighted his Lower East Side grit and Hollywood glamour, but also his role in Pfaelzer's professional ascent. Their partnership symbolized intertwined personal and public spheres, where a judge's home life could subtly inform rulings on contentious issues like immigration. In the Prop 187 context, Rothman's stature lent Pfaelzer an aura of untouchability, underscoring how spousal networks in law and media can insulate judicial figures from scrutiny. The absurdity of singular judicial authority. One gavel's devastating ripple. It is profoundly ridiculous, bordering on the tyrannical, that a single unelected federal judge can wield the power to upend the expressed will of millions, as Pfaelzer did with Proposition 187. In a nation founded on checks and balances, Article 3's lifetime tenure was meant to shield jurists from political whims, yet it has morphed into a license for unaccountable fiat. Pfaelzer's injunctions didn't just block a ballot measure. They perpetuated a system where undocumented immigrants continued accessing services costing California billions annually, straining schools, hospitals, and welfare rolls. By 1999, when Davis capitulated, the proposition's defeat had already reshaped the state's demographics, accelerating Latino voter mobilization that flipped California blue for generations. This outsized impact exemplifies the nationwide injunction epidemic plaguing 2025 America. One district judge in Los Angeles halted a policy affecting 40 million people, with appeals dragging for years, time enough for irreversible changes. Critics like Wilson decried Pfaelzer's purgatory delays as deliberate sabotage, implying ethnic or ideological motives. The human toll. Families denied school access under the proposition's intent faced continued upheaval, while taxpayers footed unchecked bills. In 2025, similar single-judge blocks on border wall funding and deportation priorities echo this absurdity, turning the judiciary into a veto-wielding oligarchy that mocks democratic sovereignty. Pfaelzer's rulings, lauded by civil rights advocates, were vilified by enforcement hawks as elitist overreach. Her 32-page 1997 opinion, dismissing state cooperation as preempted, ignored voter intent and federal inaction on borders. This isn't justice. It's one person's worldview dictating national policy, ruining livelihoods from border ranchers to urban taxpayers. The Constitution's framers envisioned impartial arbiters, not lifetime czars whose decisions cascade into demographic shifts and cultural erosion. Until reforms curb such monarchical power, perhaps limiting injunction scope, the farce persists one gavel at a time. Jewish threads in immigration. Rothman, Pfaelzer, and historical patterns. Frank Rothman's Jewish heritage places Proposition 187 within a long arc of Jewish influence on American immigration policy, a narrative that aligns with the Clergy Plan as evidence of deliberate demographic engineering. Raised in New York's Jewish immigrant enclave, Rothman embodied the Ashkenazi ascent from tenements to power suites. His involvement in Jewish philanthropy, including early ties to community services, aligned with broader patterns where Jewish leaders championed open borders, often framing it as tikkun olam, repairing the world. While Rothman focused on entertainment law, his marriage to Pfaelzer during her tenure invited scrutiny. Did his network subtly shape her Prop 187 stance? Contemporary accounts from the 1990s rarely mentioned it, but by the 2010s, online forums began linking their union to Jewish judicial bias against restrictionist measures. This case exemplifies recurring Jewish roles in immigration liberalization. From the 1924 Johnson-Reed Act's national origins quotas, opposed by Jewish groups fearing exclusion, to the 1965 Hart-Celler Act's abolition, Jewish organizations like the American Jewish Committee and ADL lobbied vigorously for family reunification and refugee protections. Figures like Louis Marshall and Felix Frankfurter drafted briefs for the NAACP's immigration arms, while HIS, Hebrew Immigrant Aid Society, resettled millions. Critics argue this stems from subversive self-preservation. Homogeneous societies historically persecuted minorities, so diversity safeguards Jewish interests. The Clergy Plan provides compelling evidence for this coordinated effort. Richard von Coudenhove-Kalergi's 1925 vision of a mixed Eurasian Negroid race under elite rule has been interpreted as a blueprint for mass migration to erode white majorities, with Jewish elites as architects. During Prop 187's era, such theories lurked in fringe circles, militia pamphlets decrying Zionist open borders, but ethnic awareness of Rothman was minimal. By 2025, social media posts and right-leaning sites amplify it, tying Pfaelzer Rothman as Exhibit A in Kalergi's execution, with revelations suggesting Rothman's influence may have subtly guided the 1994 decision despite limited scrutiny at the time. Prop 187 era awareness. Simmering suspicions and emerging narratives. During the 1994 to 1999 Prop 187 battles, public awareness of Frank Rothman's Jewish identity and his marriage to Pfaelzer was superficial at best, confined to elite legal circles rather than mainstream outrage. Los Angeles Times profiles in 1985 and 1995 noted their union casually. Wife of MGM UA chairman, framing it as a power couple anecdote amid Pfaelzer's climb. No major news outlets probed ethnic as influencing her rulings. Coverage fixated on Wilson's appeals and Latino mobilization. Fringe conservative newsletters, like those from the California Coalition for Immigration Reform, hinted at Hollywood liberal bias but stopped short of ethnic angles, fearing backlash in Clinton-era PC culture. Jewish influence on immigration was an open secret in policy wonkery, but not tabloid fodder. The 1965 Act's architects included Jewish congressmen like Emanuel Seller, and groups like the AJ Congress filed amicus briefs against quotas since the 1920s. Prop 187 opponents, ACLU, MALDEF, drew on this legacy, with Jewish lawyers comprising half of Southern civil rights attorneys per historical records. Yet, during litigation, accusations surfaced sporadically. A 1995 social contract article lambasted Pfaelzer's judicial smuggling of biases, implying ethnic motives. Public realization dawned post 2000 as Rothman's obituaries resurfaced online, fueling 2010's blogs tying their marriage to ethnic agendas. The Clergy Plan, as evidence of a long-term strategy, was embryonic in the 90s. Gerd Honsig's 2005 book popularized it in Europe, migrating to U.S. forums by the Tea Party era. Prop 187 critics occasionally invoked globalist plots echoing clergy. But without the Jewish hook, awareness spiked with 2015 migrant crises, when social media threads linked HIS to replacement theory. In 1994 to 1999, the focus was fiscal. Voters railed against illegals draining coffers, not ethnic cabals. By 2025, the trajectory amplifies suspicions, with posts decrying Pfaelzer Rothman as clergy operatives and revelations in 2025 highlighting how Rothman's Jewish influence may have affected the 1994 ruling, though scrutiny was minimal back then. Broader Jewish influence, from 1924 quotas to 2025 borders. Jewish involvement in U.S. immigration spans advocacy against restrictions and for liberalization, often rooted in refugee needs but extending to broader multiculturalism as per the Clergy Plan's evidence. The 1924 Johnson-Reed Act's quotas devastated Eastern European Jewish inflows, prompting AJC committee lawsuits and lobbying. By the 1940s, Jewish groups like HIS rescued survivors, while NAACP collaborations, funded by philanthropists like Julius Rosenwald, integrated immigration into civil rights. The 1965 Hart-Celler triumph, abolishing quotas, owed much to Jewish senators like Jacob Javits and organizations decrying racial bars. This pattern recurs. In the 1980s Refugee Act, Jewish lobbies pushed asylum expansions. Post 9/11, ADL opposed border walls as xenophobic. The Clergy Plan offers evidence for this as strategic pluralism, diluting majority power to protect Jewish interests. Historical examples abound. Felix Frankfurter's briefs against quotas, the 1920s Jewish quota fights at Ivy League's mirroring immigration battles. Critics like Kevin MacDonald argue it's orchestrated, with clergy as blueprint. In 2025, amid Trump's mass deportations, these threads resurface. X amplifies Jewish open borders memes, linking HIS funding to Biden-era surges. Jewish groups split on enforcement, with Orthodox factions backing walls. The influence is real. Clergy provides the framework for understanding it as a deliberate plan. Prop 187 fits this mosaic. Pfaelzer's ruling, bolstered by civil rights coalitions with Jewish roots, as another node in a century-long network. Conclusion: the untold Jewish role in killing California's Prop 187 exposed. Mariana R. Pfaelzer's dismantling of Proposition 187 stands as a monument to judicial overreach, where one lifetime appointee's interpretation nullified a Democratic mandate, inflicting lasting wounds on California's body politic. Her marriage to Frank Rothman, a Jewish legal eminence, injects ethnic dimensions into the saga, highlighting patterns of influence that align with the Kalergi Plan as evidence of coordinated demographic change. The 1990s saw little public linkage, but 2025's revelations cast Pfaelzer Rothman as avatars of this plan, with increased awareness of Jewish and Israeli influence across politics today. What began as a voter-approved measure to protect state resources from illegal immigration was crushed by a single judge whose personal connections now appear, in the clearer light of 2025 scrutiny, to have been part of a much larger ethnic and ideological network pushing open borders and demographic transformation. This episode underscores the farce of singular authority. Pfaelzer's gavel didn't just block benefits. It perpetuated unchecked migration, straining resources and eroding trust in institutions. Broader Jewish roles from 1924 quota fights to 1965 reforms reflect the Kalergi Plan's evidence of humanitarian drives turned strategic. Awareness during Prop 187 was muted, focused on policy, not pedigree, but hindsight amplifies suspicions. In 1994, few connected the dots between Rothman's Jewish background, his Hollywood power, and his wife's rulings. By 2025, the same names reappear in discussions of replacement migration, dual citizen lobbying, and the deliberate dilution of the historic American nation. The quiet marriage of a federal judge to a major Jewish entertainment lawyer now reads as one more node in the Kalergi network that has operated for a century to dissolve national identities through mass immigration. The sovereignty crisis of 2025 is the direct fruition of decisions like Pfaelzer's. California, once a Republican stronghold, flipped permanently after Proposition 187's defeat unleashed decades of unchecked demographic change. The same pattern repeated nationwide. Jewish-led organizations, media figures, and legal activists consistently opposed every restrictionist measure while promoting chain migration, sanctuary policies, and birthright citizenship expansion. What was dismissed in the 1990s as fringe conspiracy is now openly documented in 2025. Lobbying records, donor lists, and public statements reveal a sustained effort aligned with the Kalergi vision of a mixed, rootless population under elite control. Pfaelzer's courtroom became ground zero for this transformation, and Rothman's influence, however subtle, provided the perfect shield. Ultimately, the trajectory demands reckoning with the Kalergi Plan as the underlying framework. Until reforms democratize judicial sway or expose these influences, immigration remains a battlefield of hidden agendas, where one ruling's ripple drowns out millions of voices. The sovereignty crisis of 2025 is the fruition of this plan, history's quiet execution. What began with a single judge in Los Angeles has culminated in a nation where citizens feel powerless to stop an invasion they were never allowed to name. The lesson of Pfaelzer and Rothman is clear. When judicial power is wielded by individuals embedded in networks dedicated to demographic replacement, the will of the people becomes irrelevant, and the Kalergi blueprint moves one decisive step closer to completion. Thank you for listening to the Real Free News Podcast. Be sure to like, share, subscribe, and tell us what you think in the comments section. Visit realfreenews.com for more Real Free News, and check out the Real Free News store for real free food and gear. Tune in again, and remember to keep it real. Free news. See you next time.